Never miss our updates and be part of our conversation squad.
Yeah, good morning, everybody. Welcome to this morning's Manthan event. Our speaker today needs no introduction. She's Vrinda Grover, who is an advocate to the Supreme Court of India. She is not just an advocate, but she's also a researcher in legal issues and a human rights activist. She obtained a basic degree in law from Delhi University, and then a master's from the prestigious New York University School of Law. And as a lawyer, she has been involved in a number of landmark cases, many of them involving human rights issues. She has represented victims and survivors of gender-based violence, communal conflict, extra-judicial executions, and sexual minorities. She has also researched considerably, and her writing probes issues relating to impunity for targeted violence against minorities, human rights, and others. She received an honorary doctorate in law from the School of Oriental and African Studies in the University of London. And in 2013, the Time magazine listed her as one of the 100 most influential people in the world. Today, she will talk about a topic which has been concerning many of us and is a live issue, especially in Telangana. The title of the topic is Entrenching Impunity, Peddling Justice for Rape, a case for feminist civil liberties. The context is the police action, extrajudicial action that is taken by the police in cases of rape and other forms of sexual violence against women. Vrinda, welcome to Manthan. We have been waiting for a long time and we're happy to have you here, although this is a very busy time for you. Now the mic is yours. Yeah.
Thank you, Ram, and thank you to the Manthan Foundation for inviting me to speak on one of the most respected platforms for exchange of ideas and conversations. And a good morning to everyone and all the listeners. Yesterday, 25th June, marked the 47th anniversary of the emergency imposed by the Congress government and under the Prime Ministership of Indira Gandhi. Regimes have changed, yet opponents and critics continue to be arrested and imprisoned. In 1975, political opponents, trade unionists, civil liberty activists, student leaders, ordinary citizens were all arrested and detained under draconian laws. Habeas corpus writ petitions were dismissed as the Supreme Court of India, in the infamous ADM Jabalpur versus Shivkant Shukla, held that the right to life stood suspended during the emergency. Justice H.R. Khanna was the lone dissenter to this majority opinion. The Supreme Court, in its 2017 celebrated K.S. Puttaswamy judgment, described the emergency era ADM Jabalpur judgment as a discordant note, and expressly overruling the same, held that this was an aberration in the constitutional jurisprudence of our country and the desirability of burying the majority opinion 10 fathom deep with no chance of resurrection. On 25th June 2022, the police, on the basis of a complaint, that is yesterday, on the basis of a complaint that quoted a paragraph from a unanimous judgment of the Supreme Court in Zakia Ehsan Jafri versus State of Gujarat, arrested a prominent human rights activist, Teesta Setalwar, from Bombay and took her to Ahmedabad. The discordant notes are clanging all around us, and I hear a lot of dissonance. Perhaps there are many music rooms in this country. It's a moment of critical reflection. And I will now come to the main body of the talk that I wish to share today. And I think this juncture provides an important occasion for us to revisit many of the ways in which we have been understanding law, our engagement with law, and whether this is a juncture for taking a turn towards a feminist revisiting, reimagining of rule of law. Feminist engagement with law has always been fraught and ambivalent. This juncture warrants a reimagining of law. What can be a better moment than now to revisit the hyper-masculinist edition of rule of law that fortifies the patriarchal state? My talk today examines a contemporary feminist intervention, which incidentally took place in Hyderabad, the host city of Manthan Foundation. I will look at the sequence of the Disha gang rape and homicide, followed by the encounter killing of the 4 suspects in late 2019. Drawing upon the Commission of Inquiry report dated January 2022, I will share some of my reflections and insights. Since December 2012, following the gang rape and homicide of Nirbhaya, sexual violence against women, and in particular the issue of rape, has received considerable attention from the public, parliament, courts, media. Of course, it must be underscored here that this attention is reserved for some rapes. The systemic sexual exploitation suffered by Dalit, working class, Adivasi women receives no attention, except occasionally and only after strenuous efforts by the community itself. Targeting of women's bodies during communal pogrom and caste atrocities continues with impunity. Sexual assault committed by men in uniform in conflict areas remain highly contested and unacknowledged. And of course, the hypocrisy around sexual violence within the home persists, as dominance over women's bodies is treated as legitimate sacrifice at the altar of preserving the institution of family. A news report from 2012 undertook an analysis of political parties' manifesto in the run-up to the 2009 general election. It concluded that not one political party included the subject of sexual violence in its agenda. In 2012, women, young people, and many others took to the streets to protest against the pervasive nature of sexual violence. 10 years later, distorted echoes can be heard as the cacophony of death sentence, encounter killing drowns out women's voice seeking freedom and justice. In December 2012, a young woman, physiotherapist intern, Nirbhaya, the name assigned to her, never made it home after watching an evening show of the English film, The Life of Pi, at a cinema hall in South Delhi. Nirbhaya was gang raped in the bus she boarded to travel home and succumbed to the injuries. In November 2019, a young veterinary doctor, Disha, a name assigned to her, returning from her clinic around 9:20 p.m., was stuck at a toll plaza as the rear tire of her scooty had a puncture, the toll plaza being on the outskirts of Hyderabad. The next morning, her charred body was found. Young, educated women, simply going about doing ordinary, everyday activities, became victims of extraordinary, violent, and fatal crimes. In the Nirbhaya case, 5 men were arrested. 1 died under suspicious circumstances while in judicial custody in Tihar jail. 4 were prosecuted, convicted, and hanged to death at the break of dawn of 20th March 2020. In the Disha case, 4 men were arrested by the police, and a week later, all 4 were shot dead by the police in the early hours of 6 December 2019. Each time, the crowds cheered, applauded, and celebrated. The executors and their masters proclaimed that justice had been done, women were safe. Parliamentarians and political leaders cutting across party lines hailed the encounter killing of the 4 Hyderabad Disha suspects. The Andhra Pradesh Chief Minister said in the State Assembly, "Salute to KCR and Telangana police. If the hero in a movie kills someone in an encounter, we all clap and say the movie is good. If a daring person does that in real life, someone will come down from Delhi in the name of National Human Rights Commission and say this is wrong." In the visuals telecast that evening, women can be seen tying rakhis to policemen across the city, touching their feet, dancing to the beat of drums and marriage bands, bursting firecrackers, schoolgirls joyously putting cake on each other's face. People gathered on the bridge at the site of the police shootout, showered rose petals on the police, carried the police officers on their shoulders, raising slogans of Jai Police, Hyderabad Police, Zindabad. The Commissioner of Police, Cyberabad, B.C. Sajjanar, was lauded as a real-life Singham, the film super cop. A group of feminists and social activists did not join the chorus. Instead, on the evening of 6 December 2019, 15 women's rights activists and social activists of Telangana wrote a letter to the Chief Justice of the Telangana High Court and said, I quote, "Does the killing of rape and murder accused act as any kind of deterrent against heinous crimes? Are such killings going to make women safer? As women's rights groups, we think not. Preventing crimes against women involves a long, sustained, and complex battle that has to be fought in, among other arenas, society, our homes, educational, and workplaces. Endowing police with sanction to commit murders and of accused is no answer. They only distract and shield the state from accountability, and celebrating such killing amounts to inhumanity. Such acts are uncivilized, brutal, and those policemen responsible for today's crime must be brought to book. As women's groups, our challenges after today's only intensifies. We look up to this Honorable Court's intervention in safeguarding women's rights and civil liberties as ensured by this Constitution." End quote. Some of the signatories to this letter had, after the rape and murder on 27th November 2019 and prior to the encounter killing, visited the family of Disha to condole their grief and loss. I must, of course, place on record here that I appear as counsel for these feminists and activists who authored this letter, and I have appeared and continue to appear in this matter before the Telangana High Court, the Supreme Court, as well as the Commission of Inquiry. On receipt of the letter, the Chief Justice of the Telangana High Court directed a division bench of the court to take up the matter, suo motu at 8 p.m. on the same day, 6 December 2019. In the case now titled Representation dated 6/12/2019 of Women's Rights and People's Organizations Joint Complaint, the High Court passed orders directing preservation of the dead bodies of the 4 suspects and videography of the postmortem. During the pendency of proceedings before the High Court, the state of Telangana constituted an SIT, a special investigating team, to probe the case on 8 December. In the meanwhile, a public interest litigation filed before the Supreme Court was filed on 12th December 2019, in which the Supreme Court directed the setting up of a commission of inquiry headed by Justice Sipurkar, a former judge of the Supreme Court, and 2 others. The Supreme Court order stated, I quote, "It is desirable and necessary to know the truth relating to the incident. The death had occurred when the accused were in the custody of law. An inquiry commission needs to be constituted for inquiring into the circumstances in which the 4 persons were killed in Hyderabad." Subsequently, in the letter petition instituted in the Telangana High Court, directions were passed for conducting a second postmortem preservation of documentary, scientific, and all material evidence. I want to underline here the significance of the letter petition initiated by feminists and activists, without which the police version would be the last word on the killings. It is a matter of record that in almost every incident in India where a fake encounter has been exposed as an extrajudicial killing by men in uniform, the intervention and initiative has come from either the victim families or democratic rights organizations. The 2016 Manipur-based Extrajudicial Execution Victim Families Association, which filed the petition before the Supreme Court, a case that still continues, seeking an inquiry into a spate of encounter killings, after which the CBI was handed over the case, and of course, using legal privilege and the immunity accorded through legal privilege, the prosecution and trial is being obstructed. But it was the families, the victim families, which came together and moved the Supreme Court. The Ishrat Jahan case, where the mother went to the High Court saying that her daughter was not a terrorist and had been killed after being abducted, which is what the CBI then upheld through its investigation. It would be important for at the juncture that we locate ourselves today, to pause and recognize the significance, relevance, and value of collective interventions by social activists, by human rights defenders, who have moved courts and sought fair trials, sought fair investigations, and only then versions put out, either by the police or by the state, have been uncovered. The state has not, unfortunately, stepped into the shoes of the victims, taken those issues forward, and on its own initiative, unfolded the layers or peeled the layers of falsehood and deceit that have often suppressed crimes that have been committed against people in this country. The feminist intervention, the collective nature of the feminist intervention, which initiated the entire process, to my mind, is of great relevance. Hyderabad and undivided Andhra Pradesh is, of course, no stranger to staged encounters. It is the Andhra Pradesh civil liberties movement and human rights lawyers like K.G. Kannabiran and Balgopal, whose fact-finding reports, incisive writings, and legal interventions repeatedly unmasked the fake encounter killings by the police, critiqued encounters as state policy, and shaped guidelines issued by the NHRC in 1997, revised subsequently in 2003 and 2010, to be adhered to in killing in police action, including videography of post-mortem. It is from the Andhra Pradesh civil liberties movement's work that all of us across the country have also gained an insight and understanding of the nature of this police action and how it is, and the compact between the state and the police in executing this form of brutality and violence. The statutory law and binding directives of the Supreme Court notwithstanding, it is undeniable that the feminist letter intervention played a pivotal role in this case, putting the spotlight on the claims of the police. Much has been said and written about policing and the urgent, or rather desperate, need for a professional police force. Police reform has long been a subject of serious deliberation, from the stellar 8 volumes of National Police Commission report from 1979 to 1981, the Model Police Act of 2006, to the 7 directives issued by the Supreme Court in 2006 in the judgment of Prakash Singh versus Union of India. These 7 directions are often cited as the basic mantra for police reform. In my view, however, the thrust of the Prakash Singh case is to insulate the police from the executive, and hence the enumeration of the security of tenure and transparency in appointments, postings, and transfers. Undoubtedly, it is imperative that the police function independent of the dictates of the ruling dispensation. However, the issues policing that women confront have roots in patriarchy and prejudice, caste and communal bias, to name a few of the dark crevices where I doubt that the 7 commandments will shine any light at all. The interface and response of police to a woman would invariably be contingent on her gender and other identities and status, and not on the law or procedure. Today, however, I will confine myself to only those issues regarding policing that emerged from the Hyderabad Disha encounter of 2019. To recount a few facts. These facts are sourced from the Commission of Inquiry report dated 28 January. On 27/11/2019, a young 26-year-old veterinary doctor, Disha, was returning home from a medical clinic. She used to park her scooty at a toll plaza on the way to work and collect it from there on her return. However, on that day at about 9:20 p.m., she called her sister and informed her that the rear tire of a scooter had been punctured, and a few men assured her that they will repair the scooty. She told her sister that she was scared. At 10 p.m., when her sister called her again, Disha's phone was switched off. Immediately, her family members started looking for her. They went to the RGIA police station at about 11:20 p.m. However, the police did not register a complaint. The police said they sent a patrol car to search all toll plazas but could not find her. At 2 a.m., Disha's father gave a written complaint to the police station, which refused to take the complaint, claiming they did not have jurisdiction, and asked the father to go to the Shamshabad police station. It was only at 3 a.m. that the complaint was finally registered by the police. The next day, on 28/11/2019, the police were informed that a female dead body was found burning at an underpass on National Highway 44 on the outskirts of Hyderabad. At about 8:30 a.m., Disha's sisters and parents went to the Shamshabad police station to inquire. They were informed about the body that had been found. The family identified the body. At 9 a.m. on 28 November, the police registered an FIR. The refusal of the police to register a complaint is a recurring theme in all cases of gender-based violence. And if the woman belongs to a marginalized or oppressed group, then the prospect of the police registering a complaint is bleak and uncertain. The inertia and delay routinely practiced by the police often makes the difference between a crime being prevented or perpetrated. The gruesome death of Disha sparked a public outcry against the unending spate of sexual assault. There was widespread public ire directed against the inaction of the police on the night of 27/11. Angry and anxious, the public protested against the police as well as politicians. 3 police officers were suspended for not registering the complaint in a timely manner. 2 days later, the police claimed that on the basis of a CCTV footage, the owner of the lorry identified and named the 4 suspects who were killed in police custody. The 4 suspects, Muhammad Arif, Jolu Naveen, Jolu Shiva, and Channakeshavallu, were arrested on the intervening night of 28th-29th November from their villages. The police recorded their alleged confessional statements on 29th evening, and on 30th November, all 4 accused were remanded for 14 days judicial custody to Cherlapalli jail by the executive magistrate. An India Today article notes, and I quote, "It had been some 10 hours since the family had reported her missing. The avalanche of bad press and protests that followed all but destroyed the department's reputation of effective and innovative policing. However, the police did redeem themselves somewhat by deploying 10 teams and arresting all 4 accused within 48 hours of the crime. Soon after the arrest, the Cyberabad Police Commissioner Sajjanar announced the sexual assault on the lady veterinarian was planned. We tracked down the accused with the help of human intelligence and CCTV footage." Arrest by the police marks the deprivation of fundamental right of personal liberty and hence this power is to be exercised strictly in accordance with law as stipulated in Article 21 of the Indian Constitution. In the landmark 1997 D.K. Basu judgment, the Supreme Court noted, experience shows that the worst violations of human rights take place during a course of investigation. Does a citizen shed off his fundamental right to life the moment a police arrests him? Can the right to life of a citizen be put in abeyance on his arrest? These questions touch the spinal cord of human rights jurisprudence. The answer indeed has to be an emphatic no. End quote of the judgment. The Supreme Court then proceeded to lay down detailed directives to govern all stages and aspects of arrest and detention as preventive measures against custodial violence. When the documents and statements of the Telangana police were subjected to scrutiny by the Commission of Inquiry, the Commission concluded that the deceased suspects at the time of arrest were entitled to a number of constitutional and statutory rights that were violated by the police personnel. Every single directive issued by the Supreme Court in the D.K. Basu judgment, which was then incorporated as statutory provisions in Chapter 3 of the Code of Criminal Procedure via an amendment in 2009, was flouted, including legal provisions mandating arrest by officers bearing visible identification, contemporaneous preparation of arrest memos, information of arrest to a family member, attestation of arrest memos by a witness, information to the arrestee of grounds of arrest, right to meet an advocate during interrogation. Perhaps the reason why all constitutional rights, procedural laws, statutory provisions, and Supreme Court binding directives were so brazenly defied by the police lay partially in the status and identity of the four suspects. Three of the suspects belong to the Valmiki Boya tribe, which is recognized by the state of Telangana as a member of the backward classes. The fourth suspect, as the name suggests, was a Muslim man. The younger three worked as lorry cleaners, while Arif, aged about 26 years, worked occasionally as a part-time driver to eke out a living. The very identity and impoverishment, life on the margins, rendered them suspect and expendable. A sample survey conducted by Common Cause and Center for Study of Developing Society notes in its report of 2019, Status of Policing in India, that about half, and this report looks at 21 states, that about half of the police personnel reported that Muslims are likely to be naturally prone towards committing violence. Police personnel from Karnataka and Uttar Pradesh have the highest proportion of those believing that people from Dalit communities are highly likely to be naturally prone towards committing crimes. While in Rajasthan and Maharashtra, about half of the police personnel reported that Adivasis are likely to be naturally prone towards committing crime. The survey points to a very disturbing and grim fact that this bias in the police force is no longer a prejudice or attitude nursed by an individual cop, but rather is operating as an institutional bias at the organizational level. An alarming finding that the Commission of Inquiry arrived at was that 3 of the suspects arrested were minor boys, juveniles. At the time of their death in police custody, Chennakeshavallu and Jolu Naveen were aged 15 years and Jolu Shiva was aged 17 years. Condemned by their identity and poverty, the minor age of the 3 suspects, which would classify them as children in conflict with law under the Juvenile Justice Act of 2015, 2 did not come to their aid. So complete was the demonization that the special legal regime afforded to juveniles under 18 years was also blithely bypassed. As part of its commitment to the ratification of the UN Convention on the Rights of the Child, India passed the JJ Act in 2015. A glance at the photographs of the 3 juveniles taken by the police at the time of their arrest reveals that even by appearance, 3 of the arrestees looked like minors, or at least raises a doubt that they may be juvenile under 18 years of age. Section 94 of the JJ Act and judgments of the Supreme Court mandate that without exception, the process of age verification must be compulsorily conducted if the age of a person appears to be around 18 to 21 years. This preliminary step is a mandatory obligation cast on the police and magistracy to ensure that no juvenile is subjected to the rigors of detention in adult police lockups and prisons. Once again, however, no step was taken to verify the age of the arrestees, and all legal safeguards bypassed. In gross infringement of the JJ Act, all 4 suspects were remanded by the executive magistrate judicial custody in an adult prison and denied the benefit of bail under the JJ Act. That this grave infringement was not an oversight by preoccupied or overworked cops, but a malicious and intentional suppression and misrepresentation became clear during the inquiry by the commission. The headmaster who produced school documents establishing the juvenility of Jolu Shiva and Chennakeshavalu stated that 3 or 4 days after the Disha incident, the police had come to the school and asked for the records and taken photographs of the documents that recorded the date of birth and age of these 2. The commission concluded, and I quote, "It becomes clear from the above that apparently the police, from the physical appearance of at least 2 of the deceased, did have doubts about their age. They went to the school where Jolu Shiva and Chennakeshavalu had studied, took photographs of the relevant school registers, and thus had knowledge of the dates of birth of the 2. Yet the entire investigation record is silent over this. The only logical inference is that the facts on juvenility have been deliberately suppressed." End quote. Despite documentary proof establishing the minor age of the suspects, the police falsified the official police record by noting their ages as 19 and 20 years in arrest forms and remand papers. As a safeguard against custodial violence, Section 54 of the Code of Criminal Procedure requires a mandatory medical examination following arrest. While ensuring paper compliance with this directive, interestingly, the doctor conveniently fails to even record the age of the accused. The demonization of the 4 arrested persons was cemented in public imagination with the press conference conducted soon after their arrest by the Commissioner of Police and the DCP, where the Commissioner disclosed to the media details of the crime and the alleged role played by each of the 4 suspects. This press conference was purportedly based on the confessions of the suspects, which, according to the police, recording of which was still underway as the press conference was being conducted. The zeal displayed by the top brass of the police in announcing and sharing the minutiae of the heinous crime of gang rape and murder was matched only by the sloppiness and tardiness that defined each step of the investigation. The actions of the Telangana police here are emblematic of the utter contempt with which the police treat procedural law and safeguards. Paper trails are manufactured to create an illusion of statutory compliance. Particularly in cases relating to sexual violence against women, the police bank upon the emotionally surcharged atmosphere to put all procedural safeguards in abeyance. Procedural rights codified in law are neither a luxury that the law accords nor an empty formality. Rather, scrupulous adherence to due process alone will ensure the sanctity and integrity of the evidence on which the case will be tested. Inside and outside the courtroom, a new discourse has been taking shape, where victim rights and rights of the accused are posited as antithetical to each other. It is argued that the law has for too long ignored the victim, particularly women victims, and the human rights framework has focused only on protecting the rights of the accused. In my view, this argument is erroneous. Rights that constitute due process and fair trial are not a mathematical equation, where the enlargement of victim rights will be at the expense of shrinking or contracting the rights of the accused. These rights are interdependent, and coexistence of both will pave the way for justice. Also, accused and victim are not necessarily permanent or rigid categories, and a person may move from one location to the other as events unfold. The occasion for taking the suspects to the incident site arose purportedly because all the four suspects allegedly made identical confessions to the police. Curiously, after recording the alleged confessional statements on 29 November 2019, that the suspects hid Disha's phone, watch, and power bank at some distance from the scene of crime near the bushes, the police showed no urgency to secure police custody of the accused to recover the said articles. It was only on 4th December 2019 that the four suspects, and again not immediately, were taken to recover the incriminating evidence, but kept at a guest house, where another set of alleged confessions were recorded on the intervening night of 5th and 6th December 2019. This followed the same sequence of requisitioning punch witnesses and a scribe to record the confessions, to give them the color of extrajudicial confession and make them admissible in law. Although what needs to be pointed out here is that they were all this time in the custody of the police, and therefore it would be immaterial who is scribing and hearing it, as long as the suspects were in custody of the police. The confession would remain inadmissible except to the extent of discovery of a new fact or thing. A material difference between both sets of confessions is the alteration of the place where the accused purportedly hid Disha's articles, which were no longer the bushes, but as per the latest confession was near a big current hole at some distance from where her body was burnt. Pertinently, this is also the site where the police party shot dead the four suspects. The articles allegedly recovered from the pit were not shown by the police to the family members of Disha, and therefore their identification and confirmation remains unknown. No fingerprints of the deceased suspects were found on these articles. The commission concluded, I quote, "It is difficult to accept that there was any recovery of articles of Disha at the scene of the incident," end quote. The entire case of the police hinges on the fact that the encounter occurred when the suspects were taken to recover articles of the deceased in pursuance of the second confession. After scrutinizing the evidence, the commission notes that the pit from where the objects were recovered, which is also the place where the police shot at the suspects, was neither secured nor cordoned off. No video or photograph of the same was produced before the commission. Noting the discrepancies in different legal documents, the inquest reports, the Panchnama, the commission said, I quote, "The only conclusion that can be drawn from such discrepancies is that the scene of incident may either have been tampered or the scene has been created to suit the convenience," end quote. On examination of the records and statements of the police, the commission concluded that the deceased suspects did not make any confessional statement at the safe house on 5th and 6th December 2019. Further, since it is found that there was no second confession at the safe house, there was no necessity to enter the agricultural fields. This conclusion of the commission strikes at the very heart of the police encounter killing in self-defense theory. The commission stated, the three police officials who opened fire at the suspects are liable to be tried for the offense under Section 302, and all the other police officers of the team are to be tried for offenses under Section 302, read with Section 34, which is common intention, as the inquiry shows that the different acts committed by each of them were done in furtherance of common intention to kill the deceased suspects. The narrative of encounter killing is a familiar one. We have seen it many times on celluloid. According to the police narrative in the pre-dawn hours of 6/12/2019, a police team of 10 armed policemen, 2 punch witnesses took the 4 accused in a bus to Chattanapalli for recovery proceedings. Each accused had a handler and they were not handcuffed. It is claimed that as the police were recovering the articles of Disha, Muhammad Arif assaulted one of the policemen who was digging the pit in a bent position and snatched his service pistol, hinted to the other accused to run by shouting, hurled dust and earth into the eyes of the police officers and punch witnesses. It is stated that the other accused also threw dust and earth into the eyes of the policemen. Jolu Shiva beat his handler with a stick and Jolu Naveen beat another policeman with a stone. And Chena Keshavallu snatched the service pistol of that policeman. It is stated that while policemen and punch witnesses were wiping dust from their eyes, the accused started running away and firing. After firing into the air, warning the suspects to surrender, the investigating officer directed 3 police personnel to open fire in a bid to arrest the deceased. Within 5 minutes of the exchange of fire, there was a lull. On checking, the police found that the suspects had fallen to the ground with bullet injuries. This concluded at 6:10 a.m. All 4 deceased bear gunshot wounds in the front side of their upper body, torso, and head, disputing the theory of the suspects running away while the police party was firing and lending credence to the possibility that a clear aim was taken. The Commission of Inquiry concluded that the process is complicated enough that a person unfamiliar with use of firearms would not be able to operate a 9mm pistol with its safety latch on. The Commission of Inquiry thus notes, it has to be held that all the deceased suspects died due to injuries caused by bullets fired by the police party. It cannot also be believed that the deceased suspects opened fire towards the police party. It cannot be said that the police party fired in self-defense or in a bid to rearrest the deceased suspects. The record shows that entire version of the police party, beginning from the safe house to the incident at Chattanapalli, is concocted. It was impossible for the deceased suspects to have snatched the weapons of the police, and they could not have operated the firearms. Therefore, the entire version is unbelievable. The mandate of the law is that whenever the police receives information about a cognizable offense, it must compulsorily register an FIR, and the same is reaffirmed by the Constitution Bench judgment of the Supreme Court in Lalita Kumari in 2014. Not surprisingly, it was in a litigation initiated by the Andhra Pradesh Civil Liberties Committee and argued by civil liberty legal stalwarts before the Andhra Pradesh High Court, where the High Court concluded that despite the claim of self-defense, justification by law officers that despite the claim of self-defense justification by law enforcement officers, the law obligates the registration of an FIR against the involved police officers under Section 302 of the Indian Penal Code and initiating the process of criminal investigation. In this landmark APCLC verdict of 2009, the AP High Court had held, the then AP High Court had held, that a self-defense justification cannot be assumed to be legitimate or established on the mere assertion by or on behalf of the perpetrator without the rigor of a focused investigation for the purpose of collecting relevant evidence after registration of the FIR, incorporating the name of the perpetrators, if and as disclosed in the information conveyed, and duly enumerating the appropriate provisions of law. These principles were upheld and reaffirmed by the Supreme Court in the 2014 judgment of PUCL versus State of Maharashtra. In the present case, it is admitted that all 4 suspects were killed by policemen, yet no FIR was registered under Section 302 against the policemen. Instead, after the encounter, the police registered an FIR under Section 307 of the Indian Penal Code for attempt to murder against the 4 deceased persons. While directing the institution of a commission of inquiry, the Supreme Court commented on this FIR, and I quote, "This is rather odd, as it is obvious that no prosecution is contemplated against dead persons who can neither be tried nor convicted. The Commission of Inquiry concluded that the plea of self-defense seems improbable and unbelievable as cited by the police team. And in any case, the self-defense plea will have to be taken during trial by the policemen and directed that an FIR be registered and proceedings be initiated. The law does not accord any special privilege to the police or any men in uniform when it comes to the defense of claiming self-defense as an exception to murder. This legal defense of self-defense is available to anyone and everyone. However, this defense can only be taken during a trial and will have to be proved to the extent of being probable by the person taking the claim of self-defense. Of course, in India, the police has, despite the statute and judgments of the courts, been able to ensure that FIRs are almost invariably in encounter killings registered against the deceased, and claiming self-defense, no further proceeding takes place. This perversion of law has taken place over decades, and despite judgments, we have not yet been able to see this impunity being called into account through criminal prosecutions and trials. The state and the executive, not surprisingly, are completely silent, if not complicit, in this perversion of law and subversion by the police. Even as the bodies lay at the site of the incident in 2019, 6 December, CP Sajjanar and DCP Reddy held a celebratory press conference a few hundred feet from the site of the shootout and announced that the police had fired in self-defense. In response to a journalist's question, the commissioner said, "See, law has done its duty. See, law has done its duty. That's all I can say." The triumphalism flaunted by senior police officers at the press conference, lauding the police team for having not just cracked the case and arrested the accused, but also delivering justice in record time. The impatience and exasperation expressed by state agents with legal procedure, rule of law, due process is becoming commonplace, as the same are projected as detracting from the efficacy of law. Demolition of lives, homes, livelihoods through the gun or bulldozers, presented as the new insignia of an effective and efficient, strong state. Lawlessness is deployed as a form of governance by the state machinery. This state violence targets certain marked properties and demonized bodies, framed as dispensable and disposable. Extrajudicial killings have been systematically deployed by all regimes in different spatial and temporal jurisdictions against groups whose elimination is framed as expedient and desirable for state and society. One rationale touted for extrajudicial killing is that justice is served efficiently. The victim's right to speedy justice is upheld, given the delays that besiege the criminal justice system. These delays are indeed endemic and exhaust the victims. In my own legal practice, I have witnessed Muslim victim families of the Hashimpura custodial killings of over 40 men in 1987 by the UP Provincial Armed Constabulary secure a conviction from the court 30 years later. The Muslim victim of gang rape during communal violence in September 2013 still awaits the conclusion of a trial before the Muzaffarnagar Fast Track Court. No clamor for speedy justice for her can be heard. From the dictum of that it is better 100 guilty persons should escape than one innocent person should suffer, stated by Blackstone and Benjamin Franklin, echoing Walter, we are now witnessing the operation of a new doctrine of annihilation of suspects whose bodies bear certain markers of identity. The political class too applauds and endorses these extrajudicial killings as justice for women. Thus, the police, with the blessings of the ruling dispensation, are brazenly trespassing into the domain of the judiciary, with criminal trials and rigorous scrutiny of evidence being viewed as onerous, time-consuming exercises. Encounters offer a tantalizing alternative where the police play judge, jury, and executor. This insidious trajectory to oust courts from the role of adjudicating the innocence or guilt of a person is being carved out in the name of and for women's safety. Preying on the valid anxiety of people, women are being asked to barter freedom for safety, due process for arbitrary state violence. In this remix of the constitutional scheme, the role and purview of courts stands abridged, and the already tenuous checks on the exponential power of the executive further jeopardized. This should be a cause of concern for the judiciary. While women seek equality, sexual autonomy, respect for bodily integrity, freedom, or Bekhoff Azadi, as articulated by feminist comrade Kavita Krishnan, the state seeks to appease women by offering death sentence, lightning speed trials, and encounter killings. I will conclude with saying that the right to know and the right to truth exists for all. The encounter of the 4 suspects in the rape and murder of Disha leaves in its trail more victims seeking justice and truth. Firstly, the family of Disha, who have a right to a fair investigation and a right to justice. The right to know, which places on the state the responsibility to prosecute the perpetrators of the crime in accordance with law. The right of Disha and her family to justice delivered through a judicial verdict stands compromised. The right of all of us as citizens to know what transpired in each of the incidents. All these rights are today we are being told to give up these rights for the greater good of safety that is being offered. Perhaps it is time to move away from Singhams and develop a feminist jurisprudence which challenges the masculinist edition of rule of law, which will only strengthen a patriarchal, militaristic state. I will stop here and perhaps we can have a conversation.
Thank you, Vrinda. That's been a very exhaustive talk, especially on the Disha case. And in the last 45 minutes, I've heard so many aspects of law, especially regarding the abuse of power by the police. So my first question would be this, that while they have said that there'll be capital punishment for a rapist victim, what about the abuse of power by the police? It's only the sub-inspector, the inspector who handled the cases, they are suspended. But obviously the source of abuse is not by them, but by somebody else. How do you see that?
I think that's a very pertinent question, relevant on many aspects of law and on many situations. There is in law and in international law, a doctrine called the doctrine of command responsibility. That doctrine says that if, and this doctrine applies particularly to the police, the army, that when there are people acting under you who are, and you are in a position of authority, and those who are acting under you, if you had knowledge of what they were going to do, or you could have prevented it, or you did not report on the excesses that they have committed, then the person at the helm of affairs, the person sitting on top, the police leadership in this case, would be held individually culpable, individually criminally culpable under the doctrine of command responsibility. In fact, what we see, for instance, in the International Criminal Court, where we see leaders who have, masterminded and genocides in different jurisdictions globally, the fact that those leaders are held to account and sentenced is because the doctrine of criminal responsibility is a command responsibility is invoked, saying that you may not have committed it, you may not have stained your hands, but you were the one who was responsible for this. In fact, another parallel where this applies and which many of us have engaged with and spoken about is the sphere of mass crimes when communal violence takes place. During communal violence, we know that there may be mobs who are acting on the ground, there may be the police committing acts of omission and commission, but what about the role of the political leadership? What about the role of the police leadership? Those who allow that kind of violence to take place. The doctrine of command responsibility has to be invoked for holding them liable and responsible. And this is absent in our jurisprudence. And while presently the government says that it is engaged in revamping the criminal law, there is a huge initiative that the Ministry of Home Affairs has undertaken, where they say they are going to substantively revamp criminal law and particularly shed its colonial past. I think what would be very relevant, therefore, is to introduce the doctrine of command responsibility so that in independent India, those who are currently beyond the pale of accountability can also be held responsible for their criminal acts.
Vrinda, thank you very much for this comprehensive talk. There are some questions, a few on by way of information and another which is specifically on the police. But before that, you ended by talking about the need for a female jurisprudence on this issue, which is not Singham-like. I know this is a huge agenda, as it were. Could you kind of very broadly talk about the outlines of what that kind of jurisprudence would look like, could look like?
Okay, so
outline, just an outline. I mean, I know that's a...
Yeah, I'm not sure I'm even equipped to answer this question. And again, I believe that to think these through, we need to sit collectively and create these answers. The answers are not out there because we have a system which is actually working on certain presumptions. The presumptions being that, the police is given certain powers by law. And despite the kind of documentation we see today in India, or from the 60s to the 70s, each decade of complete abuse of power by those who are in uniform, in complicity with those who are in positions of executive positions. And yet we see that the system continues to hold the citizen as the suspect and the state as those who will be given power to determine what will be, how to go about determining what is right, what is wrong within the framework of law. The forensic truth is to be determined in a certain manner. The protections that are provided to, say, people who are in power, to in both in executive power and in police power, where does that equality subvert itself and allow the state to have certain privileges rather than responsibilities? Another aspect would be looking at people in their marginalized locations, in their vulnerable locations. For instance, how does, I think that is I'm sorry. I need to switch this off. If you will give me a moment so that I can switch this off rather than I'll just put it away into a separate room for half a second. My apologies for that.
Yeah.
We are surrounded by more devices than are under one's individual control any longer. So my sincere apologies for that. To come back to what I was saying, law does not take into account, for instance, locations. What is a crime? Non-payment of minimum wage to a domestic help is not a crime in India. However, doing certain kinds of occupations, for instance, street performers on urban streets, can be picked up for a range of crimes. So when I say feminist jurisprudence, that feminist jurisprudence is not going to look only at issues relating to women. Of course, it will look at that. But my effort and endeavor today has been to show that we need this feminist jurisprudence has to revisit the assumptions on which the present rule of law is based. And unless we revisit it and don't look at women as additive, where, for instance, the recent writings of Pratiksha Bakshi will show us that how are prisons constructed. And since there are now women prisoners, they just put on, there's some additives that are added rather than conceiving and conceptualizing the system for people. The disabled who are incarcerated in prison, the prison does not in any way can even hold a convicted disabled person. So when I talk of feminist jurisprudence, it would be really revisiting many, many patriarchal assumptions that underlie the rule of law as we know it today.
Yeah. Okay.
The question from Shanta, mostly on what you said. What would you consider the essential principles of essential feminist principles which have to be internalized by the police force?
Sorry, I missed the first part of your question, I'm afraid.
I said, what would you consider as essential aspects of feminist principles which have to be internalized by the police force?
Okay, the police, it almost sounds like a contradiction in terms, but no, I am not suggesting that we don't have a police force, but we definitely, it will not just be the internalization, it will be the envisioning of a police force as a service force. And for too long, the only conversation that goes on about the police force is how to make them independent of executive control. And there is corruption. These seem to be the two conversations that dominate the agenda of police reform. And that is not a coincidence either. If we were to look at a police force from a feminist perspective, it will have to be an enabling force, not a force that necessarily needs to have coercive powers. There will be a need for arrest. There will be need for detention. At least I do not prescribe to a mode where I think none of this is required. But there will be very, very strict scrutiny. For instance, how do you create transparency? One of the things that the Supreme Court said in 2020 judgment was, let's put CCTV cameras everywhere. In every case of custodial violence that is coming up since then, and I can tell you from one case that I am doing, the police very conveniently says the CCTV was not functioning on that day. They even get documents from some technicians saying that they have just repaired it. So the transparency and the accountability and the answerability of the police force will have to be the ground principles, not the coercive powers and authority that they are given. It is really, in a sense, what I'm saying is to rejig the equation between the citizen and the state. The present equation, and it is a colonial equation which the state does not have any issue with its continuance. The present equation is one of the citizen being suspect, the citizen being a subject of social control, and the state needing that power to exist for itself. Those kind of coercive powers have to be completely removed and subjected to continuous scrutiny and accountability.
Vrinda, there's a question from Mr. Rameshwar, who asks, can more women participation as representatives and in policy making bring about the much needed changes? This is something that has been discussed, in various groups, but maybe you would like to comment on that.
So, okay, so I would say that representation, women have a right to representation. All constituencies have a right to be represented in, whether it is in parliament, in judiciary, wherever. They have a right to representation regardless. Will they necessarily bring with them the desired change? Would remain to be seen. Some change will take place, because very often, for instance, and I can only take examples from the court, you have certain observations that the courts make, both in the judgment and in the courtroom, which strike women particularly as being either very odd, disturbing, or even at times offensive. Because the lived experience of each one of us in society is a gendered experience. For instance, to the way a rape victim's conduct is understood, or the way particularly daughters-in-law seem to be a subject of much, on which their conduct has always evoked much remarks and observations from the court. So I do think that representation may bring about some change, because the lived experience of the person sitting there would be very different from which, because eventually when courts are deciding, while they are deciding upon law, we cannot forget even for a moment, they are also deciding that somewhere those determinations that are being made are being sourced from their own lived experience. And therefore the class, caste, gender aspect becomes extremely important. Having said which, representation alone will not solve the issues that we are today confronted with. It is a different ideology. It is a different politics that will have to be infused. And the Constitution actually is not a neutral document. The Constitution, many parts of the Constitution are both pro-people and feminist in their outlook.
There's a question here from Ranga. He asks a question: should women police only be handling rape cases? Should we have a more sensitized police personnel handling such cases?
Again, my experience actually on this has been quite to the contrary. It may be that when a woman goes into the police station to make a statement, she may find some comfort in speaking about sexual violence to a woman. However, that does not what will eventually ensure that she gets justice would require more than simply somebody of the same gender, same sex listening. It will require professional policing. It will require a comprehension and both a sensitivity to the violence as well as an understanding of the violence. The experience with women police actually has not necessarily shown that they would perform better, or that the result of the case would be better, which would require marshalling of evidence, which would require a professional investigation at the end of the day. And so I would actually bat for a professional, empathetic police force, regardless of the sex of the police personnel, because those are ways in which those can be overcome, and there are ways of tackling those kind of initial hurdles. But the other aspect, which is actually coming in the way, is that across both genders, we are finding the investigation to be very, very unprofessional. And in fact, women complain of being treated very, very nastily and shoddily by all police personnel.
Ram, you're muted. Ram, you're muted.
Yeah, it's taking some time. Yeah, there's a question from Agni who asks that, on the whole, there's, people have developed a love for violence and for taking law into their own hands. Now, how can we develop an awareness of human rights and rational thinking? to that, if we can add another question, it's not a legal question, but a social one, that why are we seeing this great admiration for extrajudicial killings, especially in rape cases,
Yes.
and by men and women, and how do we deal with that? Other than saying speed up the criminal proceedings. I mean, that seems to be the issue in front of us, confronting us.
See, on the first, the two are interrelated. On the first question, yes, we've seen mob lynchings taking place, where simply on the identity of a person or something about a person's person that is considered as despicable, you think you should, and this is the despicability, of course, being in the mind of the perceiver, you think you have a right to take the life of another person. And I think these are not isolated incidents. It's completely linked to the kind of political frame that we are existing in as a country, as a nation. We don't need to go beyond our own jurisdictions of what is happening across the globe today. When the central political understanding is one of where the state's brutality is worshipped, where the state being uncaring for its citizens is not an issue for which anyone should be held answerable, but how brutally the state can act against perceived enemies, both within its own borders and outside. If that is the notion of leadership and a powerful, good state, a strong state that is today being propagated and believed, it's not surprising then that this kind of violence is so commonplace amongst us. In fact, it's an incident that was reported in the media about how a man kissed his wife. A husband was kissing his wife while taking a dip in the river, led to the public assaulting him because clearly expression of love. And this too between a husband and wife. It's not even young people or people of different sexual orientation or minorities expressing love. But the expression of love seems to be something that that is arousing anger and rage, because how society is supposed to be, how we're supposed to conduct ourselves in the social sphere, what is expected of the political leadership and the state. Violence seems to be very much embedded there, and violence seems to be, the threat of violence and the execution of violence seems to be the state policy, which is no longer something that which is today being admired. And therefore this kind of what we are seeing, whether it is in a case of rape encounters or even otherwise, I mean, invariably we'll be told that it's for the good of the nation that somebody has been eliminated. We really don't know, because nobody probes, nobody questions, and the story is shut. So how can we know any further? But particularly when it comes to women, I think there is an instrumentalization that is also taking place here, where not only there is an actual anxiety, and that we can't deny, but there is nothing being done, absolutely nothing being done to address that anxiety. And there are things that can be done. And there are long-term things, there are short-term things. None of that is being done. The only part that is being, any attention is being paid to is this kind of response. And this response is actually is further emboldening and strengthening patriarchal control over women's lives. And I mean, it all seems to actually be some conjunction of taking the anxiety and then turning it around to further reinforce the very control which in the first place creates the problem itself. And therefore we are in a space where any challenge to this kind of violence cannot be done in isolation. It will have to be done across sectors. whether it is an attack on religious minorities, whether it is an attack on human rights defenders, whether it's an attack on women's bodies. The interrelationship between this and the compact between patriarchy and state today will have to be challenged.
Yeah, thank you for that exhaustive answer, but quite disturbing. Sorry, Vikram. Yeah.
No, I was just thinking of the 19th century ban of the sati movement. And I think that the ban coincided with the social reform movement prior to that. And that is why it was possible. But here, what we are doing is that we are reacting and maybe increasing punishment. We're making a capital punishment for rape. But there doesn't seem to be a parallel social reform movement against something like rape. And how valid is that?
I think there has long been a feminist women's rights movement against sexual violence starting many decades ago. I wonder whether at this juncture, how does any social movement articulate? How does it engage with society? How does it even, how does it conduct its processes? Social movements by nature are today being demonized, regardless of what is the element. So either we stick to, if women are only speaking about asking for penalty, but but ignoring when the police kills off 4 people who we will never know what the truth is, and therefore they are, of what the police has done. As long as we don't ask those questions, and we only ask narrow questions, which does not in any way disturb the control and power of the state. When the feminist movement asks questions that are larger, bigger, because the challenge will have to be to other sources of power also, then those social movements will be demonized, will be criminalized, and that dissent will not be allowed. So that's why I mentioned about certain rapes. It's not as though the rapes in conflict areas are getting attention. It's not as though anybody is interested in giving any sentence for any of those rapes, although those women have come forward. Those women have sought justice. They have gone to courts. So it is the social movement's precarity itself today is shaping the discourse that we are hearing.
You're again muted.
I mute it so that there's no external noise. One last question, this again from Avni, who asks, what happens when a law enforcement officer perpetrates rape? Many police departments tend to close ranks and protect their own. How does a rape victim get justice in such events?
It will be a very, very, very difficult struggle for her, for which lawyers, women's rights groups, activists will all have to rally around her in terms of just taking the case forward. But in terms of law, and of course, as we know, activists today is not a good word. Activists are seen as people who are causing law and order problems in society. But in terms of law, what is very important in your question actually is that one ignored aspect of the 2013 amendments. And this, to my mind, was a very important amendment because it may pave the way further in another time cycle of our nation of paving the way further for accountability for other human rights violations also. So the law, and this is a colonial law, it gives protection to all public servants, not just policemen, but all public servants, whether it's armed forces or members of the parliament, etc. All public servants have a protection against prosecution, and that prosecution can only be initiated, criminal prosecution for any case, which can only be initiated if the appointing authority, the government concerned, gives permission. What in law is called sanction for prosecution. We know that the sanction for prosecution is very, very rare in cases of extrajudicial execution for prosecution of police officers. Knowing the kind of this legal immunity, which then spawns impunity, One amendment that was brought about in 2013 was that if there is a complaint of sexual violence against any public servant, and it could be a case of molestation or a case of rape, then in that case, sanction for prosecution will not be required, and the person will be prosecuted without taking permission from the government concerned. Of course, that is an important statutory amendment that took place and paves the way forward. How will that investigation take place? Who will investigate in the absence of, as you said, the Brotherhood of Khaki, we see is constantly in operation. All those struggles will remain. But the statutory amendment enables a step forward. Every other case battling against this kind of power, it's not just the police, it's many other positions of power and authority, where every case, and I want to just end with this, to say that the victim should fight alone. And the human rights activist and the human rights defender who stands by them is inciting them, instigating them, to my mind, is actually a way to remove the kind of support and solidarity that the victim needs in that long struggle against state power. And by hitting out at human rights activists who are standing by and supporting these long struggles in courts and elsewhere, you are actually ensuring that struggle for justice will not be able to move forward. Alone, it is hard to fight these battles.
Thank you, Vrinda. Thank you for ending with this message, with an appeal for solidarity. Thank you so much for talking about what very broadly we would like to call human rights, even if that is now seen as a rather dirty term. And if I can emphasize the importance of the rights of activists, of the rights of activists, that the work they do. Thank you so very much for talking to us today. And we do hope that you'll be back sometime soon. Unfortunately, there'll be more such issues that we need to address and talk about. So I hope you will join us. Thank you again. Thank you so very much.
Thank you. Thank you.
Thank you to all of you. Thank you.